Good afternoon, dear friends. My name is Vasily and I'm an attorney. Today we will talk about personal privacy and about privacy violations in Russia. To begin with, let me remind you that in Russian law there is article number 137 in the criminal code. It names privacy violations, the first part of which tells us about the illegal collection and communication of the information about the private life of a person, constituting their personal and family secret without their consent, or communication of this information in a public speech, public work or mass media. For this act, criminal liability is provided, which is expressed in a fine up to 200,000 rubles and also imprisonment for up to 2 years. When does this article apply? If we look at the judicial practice, then as a rule the circumstances are as follows. A boy and a girl were dating, after which the relations went wrong, they broke up, and out of anger and disappointment one of the parties begins to send out explicit photos of the other party on the net, which they had got for personal use. Thus, out of jealousy or other emotions, this leaking is accompanied by outright extortion. This is under the threat of distribution of such intimate photos. The person demands any money or material values. So, if you sent photos of your friend or relative and these photos were expected to keep private and you post these photos online or distribute them in other media, then these actions fell under article number 137 of the Criminal Code of Russia. What do you do if such actions are committed against you? If your photos sent by you to one of your friends or relatives were subsequently distributed to third parties and even more so to an unlimited circle of people on the net. If we are talking about the first part of article number 137 of Criminal Code, which provides for liability preciously for the dissemination of the information about the private life of an individual, specifically photographs, to another person, then this criminal case is initiated at the request of the victim himself in the investigative committee. If we are talking about part number 3 of this article, which provides for liability for posting photographs on the internet, then under the first part of the article an application to the investigative committee is not even necessary, and if such facts are discovered, a criminal case is initiated without the victim report. Given that this evidence of a crime is the media, here and internet, for example, the main thing you definitely should pay attention is to consolidate this evidence. How can you try to make these things better? Not to let the photos be deleted, and in order for this evidence to be secured, it is necessary to contact a notary public for drawing up a notarial protocol. The procedure is as follows. You come to a notary and provide them with a cell phone, provide special network data, login and password, after which the notary, using the data provided, examines your page on the social networks, YouTube channel, TikTok, etc., and draws up a notarial protocol. In this protocol, the notary indicates when and under what circumstances this internet resource was examined, what was found on it, while the notary takes a screenshot of this picture and records videos. What is the real practice in Russian courts? In practice, the following sentences are passed. In one case, the court imposed a fine of 350 USD, in another case 160 hours of work in community services. Punishment in the form of imprisonment rarely imposed, but the very fact of criminal prosecution will always negatively affect the person, characteristics and history of the guilty person. Summing up the above, I want to say that you can always turn to us in such cases to seek the protection of your rights, both as the victim and as the accused if you were wrongfully accused, and we can always represent you both in law enforcement agencies and court. Subscribe to my channel, follow me. Thank you for your attention. Bye.